Chapter 17, Enforcement versus Others. Another important tool to keep a brand strong and legally protected is to deal with infringement situations when they arise, whether you are the accuser or the alleged infringer. This may mean finding someone else, through attentive monitoring, who has begun using a confusingly similar brand name for a related product or service. Or it could mean receiving a notice from someone else concerned that your brand may infringe on theirs. These types of communications are generally referred to as cease and desist letters. The great majority of infringement matters are resolved without litigation, and the great majority of trademark litigation cases that are filed are resolved without a verdict from a court. In short, both sides in these matters generally have an incentive to find a cheaper and quicker solution that avoids the costs, delays, and risks of litigation. Let's talk about dealing with someone infringing your brand. If you find a possible conflict with your brand, the first thing to do is document it. Then, talk to an informed attorney. Some actions could backfire or harm your claim, so careful and deliberate investigation and action is certainly recommended. If the other business is using a confusingly similar name and it is for a related product or service, such that your customers, upon seeing their brand, could be confused or reasonably believe that there is some connection, then action may be warranted. Possible actions could range from a simple phone call or a friendly letter to a lawsuit. So, consulting an attorney about the particular circumstances and appropriate strategies in your specific case is recommended. If communication to the other business is the first step taken, as it often is, it will generally be taken more seriously when an attorney handles and sends it. Often, the first step is to provide a warning and seek a resolution in sending a cease and desist letter, which generally notifies the other party of the infringement concerns and demands that the other party stop the infringement of the mark. Now, cease and desist letters can come in many shapes and sizes. Before sending a cease and desist demand letter, one should consider the following things. Is this a real infringement concern? What are my options if the letter is ignored? What will be the next steps? What will happen if the letter is made public on social media or in some other manner? Could there be a Streisand effect where calling attention to the situation actually leads to more exposure and harm than good? You can see my blog for more about Streisand effect. Is a letter the most appropriate action, opposed to a phone call or filing suit or some other action? Should that letter be strong or should it be gentle? Should the letter be sent via email, regular mail, certified mail, or overnight delivery? Is there counsel, a registered agent, or another address to whom the letter should be sent? Are you prepared if, upon receipt of the letter, the other party files suit in court for a declaratory judgment of non-infringement? And finally, the most important consideration before sending a cease and desist letter: are you sure that the party to whom you are writing was not using the trademark first and cannot respond by asserting a claim against you and flipping it around? Each situation is unique, of course. The advice of experienced counsel is strongly recommended and tremendously valuable. As a tip, when you discover an infringement, move quickly to deal with it, because the more time, money, and emotion that the other business invests in building their brand, the more likely they are to put up a fight to protect it. Now, what about receiving a cease and desist letter? Brand owners who receive a cease and desist letter, a demand from one company to another telling them to stop or limit use of an already trademarked or protected name, product, service, slogan, or logo, should not take it lightly. Failure to respond may make the matter more complex, more risky, and more expensive. In dealing with such a scenario, key considerations to address include: how similar are the names, products, services, or logos? Are the businesses related? Who used the name first? Is there a compromise that might be reached? If the two companies vary greatly in size, might one end up looking like a bully? These are important considerations. Business owners who do not properly clear and protect their trademark may face a difficult conundrum. They may have to pay lawyers to defend a trademark case that might not be successful, or they may have to spend money to rebrand and manage the ensuing challenges of letting go of their original name and communicating the change to customers. Of course, many allegations of infringement are worth defending, but sometimes, even if the legal defense is fairly strong, defending the case may not be the best business decision. In some instances, facing potential trademark infringement litigation could be a blessing in disguise, as it provides a chance to rebrand, recommit to the business, and restart a refreshed brand on a clean slate. If the name you have chosen is not distinctive, is not protectable, and does not communicate a message to your customers, you may actually be better off rebranding with a new, better name instead of sinking money into defending a claim.